Hello, everyone, and welcome to One Civil Law. For today's case, we have a strange situation where one government attorney is going after another government attorney for reasons that are a little bit unclear, but this is a case of Dwight Sterling versus Larry Mishinen. In this case, we have two people who are a member of the JAG Corps. That's the military. That's the military's lawyers. Yes, the military does definitely have lawyers, and this is the military's lawyers. And in this situation, one of these lawyers is licensed to practice, but not in the state that they happen to be in. But they are doing law for the JAG, so it doesn't matter. But this other guy is really, really salty about it, and apparently this is not the first time he's been really, really salty about it and trying to get all his fellow attorneys disbarred. I don't know what his problem is, but let's just go to the end of the page on this one. All right, they're in a federal practice. The federal government has the right to regulate its own courts. So as long as they're doing things within the federal court, the state of California doesn't have any say on it. But let's read the details. This is weird. Let's get started. Dwight Sterling is an attorney in the Judge Advocate General Corps of the California Army National Guard. He is a member of the California State Bar, but not all of his colleagues are. Applicable federal law requires only membership in good standing of the bar of any state, territory, or District of Columbia to practice as a JAG attorney in limited ways, including as relevant here, when those attorneys defend members of the California Army National Guard in administrative actions, investigations, or inquiries. Yeah, this is pretty typical for federal lawyers in general. You'll see this in federal prosecutor listings too, right? The federal government doesn't really care very much if where you're licensed, because the federal government could have its own bar and its own licensing, but they're like, why bother? So as long as you're a member of a bar anywhere, the federal government is quite happy for you to practice and inside the federal system. And it's like, yeah, that's fine. So I'm not quite sure what this guy's problem is, but yeah, this is not unusual. There are a lot of U.S. attorneys running around out there who are licensed in one state but are practicing federal law in a different state. The key word of that sentence being practicing federal law in a different state. So, the federal government is master of its courts just as the states are master of its courts. So, whatever. The California bar has concluded in response from Sterling that such practice is consistent with California law. So the State Bar of California has said it's cool by us. Not that it's clear they could have said anything else, but they said it was cool. If they said it was uncool, we'd have a federalism fight, and the federal government would certainly win. But the California bar said it's fine with us. We don't care. Nevertheless, Sterling, for reasons that are unclear, has tried unsuccessfully for a number of years to obtain a ruling that his colleagues must also be members of the California bar. Why? I don't know. Sterling now also appeals this district court's order denying the motion to remand the case to a California state court, where he wants to pursue his claim that a JAG colleague, defendant Lawrence Mishinen, is engaged in the unauthorized practice of law because Mishinen is licensed only in states outside of California. No one cares, except for you. Mishinen, represented by the United States Attorney, removed this action against him to federal court. Yeah, okay, so the United States Attorney is representing him because you're going after a federal official for things that they are doing. And so the United States Attorney is going to help you out. And he's going to remove it to federal law. So you tried to go to state court. And the federal government's like, no, 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 no. You can't do that. One of the ways we have jurisdiction is if you are dealing with a federal issue. And this is one of our employees, as a federal employee. So, your state level concern is super interesting and everything, but we're going to take it to federal court, because you're coming after one of our employees. We'll defend it there. And the federal courts are going to look at you and be like, what is your problem? But, that's where we are. The issue has been framed by the background of these proceedings. Mishinen is an attorney licensed in Tennessee and Arkansas. He lives in California and serves as a regional defense counsel in the California's Army National Guard JAG Trial Defense Services. In response to a complaint from Sterling, the California State Bar previously determined that, as a National Guard attorney, Mishinen is not engaged in the unauthorized practice of law in California. Nonetheless, Sterling filed this action against Mishinen in state court, seeking a writ seizing Mishinen's law practice for having engaged in the unauthorized practice of law. No, this is just none of these things. This is a federal issue, federal employee doing federal stuff. So, whatever. The district court denied Sterling's motion to remand and then dismissed the entire case on the ground of the issue preclusion, reasoning that the same issues had already been resolved against Sterling in his earlier similar case against a different colleague. So, as I said, this guy seems to have a problem just generally with his fellow colleagues for some reason. On appeal, Sterling challenges only the denial of the remand. While Sterling's reason for wanting Michigan declared unqualified to serve as a JAG attorney in California are not clear, Sterling's desire to have the dispute resolved in California is apparent. Members of the California Army National Guard, like their counterparts in other states, serve both the state in which they're located and when the federal government is needed. When memberships are called to federal active duty status, they serve pursuant to Title 10 of the United States Code, which pertains to all active duty members of the United States. So there is in the National Guard a separation between when you're in like active duty under the authority of the U.S. government and in a more passive duty, when you're being regulated by the state authority versus the national authority. So most of the time, the National Guard, despite its name, is under the authority of the various governors. And so we saw this recently, where various governors were using National Guard assets to help like monitor plates and, make sure people are quarantining and so forth. Normally not a problem because normally it's state level action in terms of the individual states. And if they're acting under national compasses, then it's national. So there is that separation, yes. Accordingly, Sterling's major argument in this case is that because National Guard members in reserve status are under state control, this guy's practice of law must solely be a matter of state interest, with his appointment and practice traceable only to state law and not to federal authority or federal officials. We disagree. Yeah, I disagree that too. Who has commanding authority under any given moment is one issue, but no, this is being federally regulated and federally controlled, and there's federal law dealing with what they can and cannot do on various situations. So no, it's not a matter of strictly state interest when he's when the National Guard. Then the state governor may have the authority to deploy him and help engage in certain things, but the federal interest is still there because as you might expect, the national government has rules on the National Guard. That's one of the reasons to make it national in focus. As to whether Michigan was acting under a federal officer, the statutory language must be liberally construed in favor of it being removed to the federal court. There is a causal nexus between Sterling's claims and Michigan's actions pursuant to a federal officer's directions. Our inquiry focuses on whether Michigan was involved in an effort to assist or help carry out the duties or tasks of a federal superior. The relationship between someone acting under the federal officer and the federal officer typically involves subjugation, guidance, or control. Michigan's practice reflects the type of federal supervision and management envisioned by the applicable federal regulations and guidance. Regional Defense Counsel in the Defense Services, including Michigan, are JAG attorneys who provide defense services to National Guard members pursuant to federal law. Michigan has raised a colorable federal defense under the Supremacy Clause as well. So yes, there's also the Supremacy Clause of the federal Constitution, right? The federal Constitution is supreme, and this is being done to federal law. So there's also this issue that, because the federal government has an interest here, that the state government can't overrule because the Supremacy Clause is saying, this guy also has an argument here under the Supremacy Clause as well, because of course he does, because he's doing it pursuant to federal law. As discussed, Michigan was appointed by and reports to a federal officer and is permitted by federal regulation to practice law in a specific and limited capacity without becoming a member of the California Bar. Michigan has a colorable defense that this is a federal regulatory scheme preempts a claim by a private individual that would have the effect of invalidating those regulations in states like California that do not require all the attorneys to become members of the California Bar. We do not express a view on whether this defense is in fact meritorious, only that it is colorable. We would also express no view on whether a similar defense will be colorable against a claim brought in a state that does expressly require members in its bar as a member of JAG service. So they're just simply saying here that we're not going to reach on issues we don't have to reach. Constitutional avoidance, right? So it's we're not going to raise this issue, and we're also definitely not going to decide the issue of what happens if you're in a state that does require to be a member of that state bar in order to be a member of the National Guard there. What if that happened? It's we're not going to figure that out right now because we don't want to. But there might be a Supremacy Clause issue there if it was being done by the federal government. And one would think, because again, they're doing things in the federal capacity, and the federal government has a right to, have its things too. Because Mission improperly moved this action as someone acting under a federal officer, we need not decide whether the United States itself is appropriately viewed as the real party interest defendant to this case, or whether the case was removable under a statute that specifically removals by members of the armed forces. So yeah, there are other things that could have given the federal government, the federal court, the authority to hear this thing, right? If it's against a member of the armed services, that would have given jurisdiction. If it was because of statutes dealing with, because the United States is actually the real person at issue, that would have been things like, no, we already have jurisdiction. We didn't have to decide if we also had jurisdiction for these other reasons, so we don't need to figure that out. Okay. The district court properly denied the motion to remand this matter to California because he was acting under the federal official authority within the meaning of federal law, thus affirmed. So that is the matter of Dwight Sterling versus Larry Missinen. In this case, we learned that one JAG attorney has a thing against attorneys who are also JAG attorneys who are not members of that state bar. I'm not quite sure why there's this problem. It's not specified here. I'm not sure what this guy's problem is, but yes, it's not really a problem. The federal government can have attorneys and the state bar doesn't have a problem with it, and it's all fine because it's all federal practice. So I'm not sure what the issue is, but that's the end of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.